Hello and welcome to the Brinks, Hofer, Gilson and Leon 2012 IP forecast. My name is James Sobieraj, the president of Brinks, Hofer, Gilson and Leon. Last year I was honored by my shareholders to become the president of the firm beginning in January of this year. Today it's my honor and pleasure to welcome all of you to our 2012 IP forecast. As you know, in our current economic climate, the value of intellectual property has never been greater. Business owners and business executives are keenly aware that intellectual property can contribute significantly to their success, and increasingly IP is being viewed as a strategic asset. 2011 was a year of significant change. We saw Nortel sell its portfolio of patents for $4.5 billion. We saw Motorola being acquired by Google for $14.5 billion, largely so Google could have access to Motorola's large portfolio of patents. After several years of deliberations and negotiations, Congress finally passed a significant and sweeping patent reform bill. A lot of the changes we saw in 2011 will have an impact this year. Further changes are on the way. In today's 2012 IP forecast, three of my esteemed colleagues will share their insights on some of the impacts the changes that were enacted last year will have this year. They'll give their insights on further changes they see coming down the road this year and offer suggestions on things you can do to help manage these changes to help your company. As a new president of Brinks, I want to reaffirm our sincerest commitment to help our clients achieve their legal and business objectives. Brinks is one firm that can help clients with a comprehensive IP strategy individually tailored to their individual needs, including identifying IP assets, procuring protection in the form of patents, trademarks, and copyrights, managing an IP portfolio, and enforcing and defending IP rights. Brinks offers a deep roster of IP experts in every facet of intellectual property law and in every field of technology and science. We have over 140 attorneys and patent agents who practice intellectual property law full-time. We're the largest full-service IP firm between California and Washington, D.C. We have 6 offices nationwide. Our headquarters is in Chicago. We also have an office in Washington, D.C. that anchors our ITC practice group. We have an office as far west as Salt Lake City and as far east as the Research Triangle Park in North Carolina. We have a strong core in the Midwest. Brinks, Hofer, Gilson and Leon is one of the leading IP firms in the country. And today you're going to hear from some of my colleagues that have helped burnish this reputation. Let me introduce them. Our first presenter today will be Drew Stover. Drew is the chair of our patent prosecution group. He'll be followed by Ralph Gabric, the chair of our litigation practice group, and John Gabrielides, the chair of our trademark practice group. Each of them will provide important insights on developments they anticipate in 2012 and offer suggestions on things that you can do to help manage these developments. After all the presentations are finished, we'll have time reserved for questions and answers. For those of you in the room, please hold your questions to the end, and I'll take them then. If you're joining us by the internet, and we have a number of people joining us via the internet, including some friends in Europe, and a long distance welcome to them, you'll notice on your screen on the right-hand side a chat window that you can use to submit questions at any time. They'll be delivered to me during the course of the program today. When I come back up, I'll offer some observations about some of the things my colleagues have said, and then take the questions and answers. We'll finish promptly at 10 o'clock today. We know a lot of you have other important commitments. We'll answer all the questions we can to the best we can in the time available. To the extent time does not permit, someone will follow up with you. At this point, I'd like to start the presentation and bring up my colleague, Drew Stover.
Thank you, Jim. Good morning and welcome. As Jim mentioned, the American Invents Act was passed last year and there have been some significant changes that have taken place already in 2011. Some further changes are going to be taking place this year, and as well as further inroads being made in 2013. I'm going to talk briefly about a few of those things today. Any one of them could consume a 3-hour seminar. So obviously we're not going to be able to dig too deep, but I did want to provide a few insights and things to think about as you go forward this year. I've kind of broken it down into two areas, playing offense and playing defense. With the Super Bowl coming up, I thought it was a proper analogy. Playing offense, the things I'm going to touch upon is the first inventor to file. And in conjunction with that is going to be the way the prior art is defined and how that's changed and some of the effects it's going to have on our practices. The second thing is track 1 filings. I think those are starting to get traction. I believe there's going to be an uptick in those filings in the coming years. Virtual marking, I'll touch on that briefly. In terms of playing defense, we're going to talk briefly about post-issuance options, and there's many of them, some online right now, some coming online later this year and into 2013. Third-party disclosures. I think that's going to be an important vehicle for submitting prior art. In the past, it's been, people are very skeptical of that, but I'll get into some of the reasons for that. And then finally, prior commercial use defense. So let's talk briefly about first inventor to file. Basically, the change is to bring us more in line with other jurisdictions around the world. There are some exceptions. It's not a pure first to file system, as I'm sure you're aware. The effective date is going to be for applications having an effective priority date of March 16th, 2013. So there is some time to consider a strategy for this change and get processes in place to accommodate that strategy. In essence, there's not going to be any swearing behind anymore, and there's not going to be any interference contests. It doesn't mean those are going to be going away for applications filed before that date. So one of the things that's going to be very important is the companies and clients need to preserve documentation surrounding their inventions for a number of reasons. The one I just mentioned, for applications that have already been filed, you want to be able to support interference proceedings even after March 16th. A new process or procedure that's going to be coming online is derivation, so that if there's 2 applications and one applicant derived the invention from the other, there's going to be a process for determining who was the true inventor. And again, it's going to be important to have documentation supporting that. Public disclosure. Even though we're going to a first to file system, if you, the inventor, disclose your invention, it can act as both a sword to invalidate others that are filed after your public disclosure, as well as a shield to protect your own subsequent filing. So it's going to be very important to document what's been disclosed, when, and how. So the insight to take away there is, it's going to be important to preserve documentation and have good record keeping. Another consideration, obviously, is going to be when should we be filing applications? And I speculate there's going to be a rush to file right before March 16th, 2013, especially perhaps if you've had inventions that have been percolating for some time. Maybe you can support diligence and other requirements, but you've had a long lead time of design. Maybe you want to get those in before March 16th. You have to understand, I think the attorneys are going to be very busy filing things. So the earlier the better that you're considering these things and you can prioritize filings. Avoid mixed priorities. That simply means if you have a provisional, maybe get the non-provisional in before the effective date, because if you can add new subject matter after, then you might have different rules applying to the same application and the different claims. So some of those things I just talked about, developing these internal timing metrics. You want to be able to identify your new inventions, prioritize your disclosures. I think it's going to be important to provide and prepare and provide complete disclosures. That's going to facilitate and expedite the filing process. Again, tracking dates of public disclosure. And then finally, joint ownership. One of the exceptions to the rule is going to be if a prior filed application had joint ownership with a subsequent application, then there's not going to be an exclusion, or the second application won't be found invalid. So you want to make sure those agreements are in place, all the I's are dotted, T's are crossed before you have those subsequent filings. As I mentioned, the public disclosure, there's been a lot of talk about that on the blogs and speculation. For example, if you're not interested in foreign protection, why not just make a public disclosure? It could negate other people's prior art, create your own prior art against others. I think that's still a risky proposition. For one, you could be giving up your 18 months of secrecy, the pendency till publication. Why not file a provisional application if you're thinking about that? Finally, there might be a question about whether the public disclosure you made was adequate or not. So just some things to think about. At the same time, if you do have a public disclosure, maybe inadvertent, document it, make sure we know what it is, the timing, etc., so that it can be used to your advantage. I'm going to shift gears a little bit and talk about Track 1 filings. These came online September 26th. I think with Track 1 filings, the important thing is going to be to do a cost-benefit analysis. Basically, you can pay some money and get your application examined really fast. And the statistics so far show that is happening. Things are coming out, office actions are being issued within 30 hours of once the granting of the request. It's by the regulations, I think it's supposed to be within 3 months, but things are happening very fast there. So if you have an identified competitor that's a potential infringer, a potential licensing opportunity, this might be something you want to consider. Or if you're stuck in a group that's taking 42 months to get a patent out, maybe it's another way to circumvent that for your crown jewels or important assets. There is a large fee up front, a $4,800 fee for large entities, and there's going to be a $10,000 maximum filing. I think between the end of September and the end of the year, there were around 1,200 filings. So you need to keep a watch of that. If this does become more popular, it's something that you should consider filing early. It requires careful preparation up front. If you're missing one of your dotted I's or crossed T's, you can be taken out of the program, no refund of your fee. Another advantage to this is you could assess patentability. If the examiner comes up with some prior art, now, presuming you've done some searching and you feel like you have a fairly good case for this Track 1, but let's say the examiner comes up with a really good piece of prior art. If it hasn't published yet, one option is to perhaps abandon the case, and then you can preserve your secrecy of it. Or you could start off, if you aren't interested in foreign protection, by electing non-publication. Presumably, you're going to have that final disposition within 1 year. If the case has been allowed, on the other hand, you could consider PPH. I think some people have been skeptical of that program and its value in different jurisdictions, but certainly something to consider. Just touch very briefly on virtual marking. I think for clients and customers, it's going to be a very easy process to handle your marking. In the past, you had to apply the labels to all the products. You had to worry about mold changes and expensive procedures when patents expired. Going forward, set up a URL or a link to your website, and on there you just need to make sure that you're associating a particular product with the patents and it's freely accessible to the public. It'd be a very easy way to control and manage your marking requirements going forward. Let's talk a little bit about playing defense. There's a lot of post-issuance possibilities coming online. I think the takeaway here is monitor, monitor, monitor. If you're not doing it already, you should be looking at key competitors, assignors, key inventors in the area, subject matter, etc. There can be a whole plethora of things that you could set up in a query. You should do it frequently and look for those types of things that you should be concerned about. The first post-issuance option I'm talking about is the post-grant review. That's not coming online for some time. For applications having a priority date of March 16th, 2013, there is going to be some interplay with litigation, so that if you filed a lawsuit, a DJ for example, it's not going to be eligible for you. So you want to be considering those options before you pull the trigger on any of them. There's going to be significant estoppel. There is going to be transitional proceedings for challenging business method patents if you've been sued and the patent's issued after September 16th, 2012. So yet again, another option to consider. Inter-parties reexamination. It's going to be transitioning to inter-parties review as of September 16th. The takeaway here is inter-parties review is going to have a very limited number, and more importantly, there's a clock ticking right now. If you were sued or there's a lawsuit initiated and served, you have 1 year to initiate an IPR. So if you had a lawsuit filed against you and you're considering this as an option to invalidate the patent, you want to consider the inter-parties re-examination before September 16th, 2012. After that, you'll be precluded from pursuing that option. Ex parte review, substantially the same. There were some recent rules proposed, and it was somewhat surprising to me that they're looking at a significant fee for ex parte examination on the order of $17,000, jumping up from $2,200. So, and in combination with supplemental examination, which has a significant fee, if the supplemental examination is granted, then it goes to ex parte, you're looking at around $20,000 just in fees. So what it tells me is that, you know, the Patent Office has given us a lot of very valuable tools here, but we'll have to wait and see whether they're all made out of gold or not and how useful they're going to be, because I think there's going to be some significant fees. There's been some talk about inter-parties review and the post-grant review having fees on the order of $40,000 or more. Which plays into the next slide, third-party disclosures. In the past, I think it's been very rare once you had to submit something before an application published. You weren't allowed to comment on it. Now the rules have changed. You can submit concise explanations. In fact, you're required to do so. It's low cost. The window of time has been opened up so that if you make this submission before a case is allowed, or also whether there's a first office action or 6 months from publication, there's an interplay between those 3 dates. But there is a larger window for submitting these disclosures. You can do it anonymously, there's no estoppel, and if you have a really good piece of prior art, it might be something to consider, especially given some of the proposed fees for the other options. And finally, I'm going to talk about just briefly prior commercial use defense. This came online will be coming online September 16th, 2012. It's a personal defense, so if you've been practicing a process or a machine, manufacture, or composition of matter used in a manufacturing or other commercial process for at least a year before the effective date of the application or the public disclosure if there was one, then you can use that as a defense to fend off a charge of litigation. Again, it's going to be very important to keep good records. I think this might be an opportunity for clients to consider trade secret protection. You know, there's some danger there. It still has to have been at least a year before somebody filed, so there is that window. And also whether it complies with the different requirements set forth. But again, it's something to consider and look at. The defense is transferable, so if you are considering an agreement, a merger or acquisition, you want to make sure that you've considered that in putting together the documents. And with that, those are my thoughts for today, and I'd like to introduce my partner, Ralph Gabric, who's going to talk about litigation.
Thank you, Drew. Good morning. For those of you out in internet land, I apologize. I'm not going to stare at the camera. We have a room full of people, so I'm going to look around the room as well. I'm going to talk a little bit about what I see happening in 2012 and perhaps beyond, looking into my crystal ball. And I recognize my crystal ball may be a little bit different than some others' crystal balls, so bear with me. Let's start with the American Invents Act. Not only is this going to affect prosecution, but I think it's going to have a fairly dramatic impact on litigation going forward. And I'd like to talk about that. I'm going to talk about how I think it may move the fight to the Patent and Trademark Office and away from the district courts to some extent. I also want to talk about how the American Invent Act will affect MPE litigation. I think there's going to be a paradigm shift. In fact, I think we're seeing that already. And by NPEs, I'm referring to non-practicing entities, or sometimes cynically referred to as patent trolls. I will also quickly address the International Trade Commission and the trends I see happening there. And then finally, I want to mention biosimilars. There was recent legislation, Obamacare, that introduced a new abbreviated pathway for biosimilars, similar to what we have in the pharmaceutical area for generic drugs. The American Invents Act, or the AIA, or sometimes referred to as Corporate America Invents Act because some individual inventors feel like they did not get a fair shake, institutes various PTO proceedings that I think will offer an alternative to district court litigation. And I'm going to skip down to the post-grant review, inter partes review, and those post-issuance proceedings that I think will affect litigation. With respect to post-grant review, this is a procedure where you can challenge a patent within 9 months of it being issued. There's a 9-month clock ticking. And you can challenge that patent not only based on prior art under 102 and 103, but you can also attack the patent's validity based on 112 as well. That previously was not an option available. With respect to inter partes review, that's intended to replace inter partes reexamination. And with respect to that, you have a 1-year time frame within which being sued on a patent to get that inter partes review filed. So the clock does begin ticking. Also, you're limited to attacking the patent based on 102 and 103, based on prior art publications. So there is a restriction. In both post-grant review and inter partes review, you will have a right of appeal, which is important. Moreover, it looks like you're going to have some opportunity to take some limited discovery in these proceedings. The extent to which discovery you will be able to take remains to be seen. I expect to see rules on that. Now, why would somebody consider fighting in the patent office the validity of a patent rather than a district court litigation? Well, there's several reasons that immediately come to mind. Number one, the patent is not presumed valid in the patent office. In district court, it's presumed valid. In the patent office, you don't confront a clear and convincing evidentiary burden. In the district court, you do. In the patent office, you have a technically savvy decision maker, somebody who's experienced in the technology. In the district court, if it's a bench trial, chances are your judge is not a physicist or a chemist. And if it's a jury trial, I can guarantee you that everybody on that jury is not going to be a physicist or chemist. So you will have a technically savvy decision maker. And in the patent office, you have a faster and cheaper proceeding than in district court. These new post-grant reviews and inter partes reviews, there's a 1-year time limit in which the patent office has to complete it. There's no 1-year time limit in the district court, and often it's 2, 3, 4 years. So how does that affect you going forward? Well, I think if you're sued for patent infringement, you need to seriously consider the patent office as an option in fighting the battle there rather than district court. And it's not an either. It's a case-by-case analysis. Some cases are better suited for a judge and jury. Other cases are better suited for the patent office. I'll give you just a simple example. Say you don't have very good non-infringement defenses. Even worse, say you have a copying problem. I would recommend that you get out of that district court as fast as you can and fight the battle in the patent office. The next thing I see the AIA impacting is NPE litigation. And we've seen a paradigm shift already. And first, before I get to the paradigm shift, I want to give you a little bit of context. Prior to the passage of the AIA this fall, NPEs would typically name tens or hundreds of defendants in the same lawsuit. And that resulted in certain procedural advantages for the NPE and disadvantages for those of us who were defendants in the lawsuit. Typically, the NPE would secure a favorable forum against all these defendants, such as the Eastern District of Texas. It would reduce costs for the NPE because there are efficiencies associated with throwing a bunch of defendants in one case. And it's a disadvantage for defendants because it would force, and I say us because I'm typically on the opposite side of the NPE case with a bunch of other defendants, it would force us to come up with common defenses. And typically our products were different. We had different issues. And when it came to claim construction, you could not always reach an agreement on the appropriate claim construction. In fact, sometimes defendants would become their own worst enemy. Basically, the defense would get reduced to the lowest common denominator. What's the claim construction that everyone can live with? And that's not good if you have particularly strong positions, and it tends to dilute your defense in that case. It was definitely a pro-NPE playing field prior to the AIA. So what did the AIA do to address this? Well, they implemented limitations on joinder. It's no longer the case now that a NPE can sue a bunch of defendants in the same lawsuit just because they allegedly infringed the same patent. You need more. You're going to have to show, if you're an NPE, that the products are the same, or essentially the same, that you have a fairly substantial amount of overlap of facts and law at issue. Like I said, allegations that you infringe the same patent is not going to be enough. So this means that the NPEs are now going to have to sue differently situated defendants in separate lawsuits. Now, NPEs have smart lawyers, and they have strategies to deal with this, and this is some of the strategies I think they're going to employ. To the extent they can, they're going to sue these individual defendants in the same district. They can get jurisdiction, and they'll try to take advantage of local rules that where cases are related, sufficiently related, they may be informally or even formally consolidated within a district court for pretrial activities such as discovery and claim construction. That's one procedure they're going to take advantage of. Another procedure, in those instances where they cannot get a bunch of defendants in the same district, they'll file in the various district courts throughout the country and then move to consolidate these cases for pretrial activities through the multi-district litigation panel. And what that means is basically you'll have one district court who will handle all the pretrial proceedings, discovery issues, claim construction, and even dispositive motions. So I think you're going to see NPEs take advantage of that. And then finally, I think you're going to see NPEs increasingly looking towards the ITC to get around this joinder problem. And in the ITC, you can sue multiple defendants, even though they don't have the same products in the same action. So, what does that mean for you if you're an NPE target? Well, seriously consider moving the fight to the PTO. Also look for misjoinder, non-joinder issues. If they've made the mistake of suing more than one party that aren't sufficiently similarly situated, move to sever. Move to transfer a different form if you can. If you're sued in the ITC, consider filing a re-exam as an insurance policy. You're not going to stay the ITC proceedings, but look, these new re-exam proceedings, these post-issuance grants and inter-party re-exam, or they have a one-year time period in which to complete themselves. Perhaps you can get a victory in the patent office before the ITC proceeding concludes, or perhaps you can get a decision in the patent office before they can get a money claim against you in a district court after the ITC. These are things to think about. Next, I want to talk briefly about the ITC. I think you're going to see not only NPEs increasingly looking to the ITC, but you're going to see just patentees in general. And the reason why is you get injunctive relief if you win. You don't have to make the separate showing that you need to do in district court. They're going to shut down these products at the border if you win. Now, you don't get money damages in the ITC if you're a patentee, but you do get findings of fact. And oftentimes they'll file the patentee parallel district court proceedings. You can take your victory from the ITC, go to the district court. We won, patent's valid, infringement, collateral estoppel. All we're here to talk about is how much the defendants owe us. Now, what are the other advantages of the ITC over the district court? It's fast, extremely fast. Start of discovery in the ITC, 30 days. versus typically 3 to 4 months in a district court. Time to trial, 6 to 9 months in the ITC. District court, 24 to 28 months, and I'm being generous. It's oftentimes more than that. Decision, 9 to 12 months in the ITC. Several years in the district court. And final decision, post-trial remedies, 12 to 16 months in the ITC, 28 to 30 months at district court. Again, being generous. Cases are increasing at the ITC. Here's some data. As you can see, the trend is going upwards, especially from 2009 through 2011. It's more than doubled. And based on a very, very, very small data point for 2012, we have 6 cases as of January 18th. Now, you take that trend throughout the year, we're on a trend or a track to have more than 200 cases in the ITC, more than double in 2011. And most of the cases are patent cases in the ITC, the overwhelming majority of them. Finally, biosimilars. The Patient Protection and Affordability Act, sometimes known as Obamacare, was passed in March of 2010. And buried at the very end of that act is a sub-act, so to speak, called the Biologics Price Competition and Innovative Act. What is that? It's an abbreviated pathway for biosimilar products. Basically, the Obama administration, taking what we've learned from generic drug products, believed that by having an abbreviated pathway that would encourage biosimilar biologic products, that the prices of drugs or biologics would go down. And basically, you file an application with the FDA, show your copy of the branded biologic product is either biosimilar or interchangeable with that branded biologic product. Now, why does that matter to patent lawyers? Because there's a detailed litigation dance that occurs once somebody files a biological application for an interchangeable or biosimilar product. However, both the regulatory and the litigation process is much more complex with biosimilars than it is with your typical pharmaceutical product. And why is that? Well, I have a little diagram here, a little graphic that displays a typical biologic product, which is typically a very complex protein. And that's the arrow labeled biologic. And then that little square is a blow-up of one piece of that molecule, and it's compared to a drug aspirin. As you can see, a biologic molecule is incredibly more complex than the typical pharmaceutical product. And so that means that showing biosimilarity is going to be much more difficult in the biologic context. From the regulatory perspective, expect to see regulations from the FDA any day now. I mean, literally, it could happen today or tomorrow, where the FDA will provide guidance to the industry. This is what you need in your application. This is what you need to show biosimilarity or interchangeability with the branded biologic product. And from a litigation perspective, I think you're going to see this year the complex litigation dance that occurs in the structural framework that's been set up for challenging biologic patents, where positions are taken, patents are chosen to litigate in a very compressed time period. And so what does that mean to you folks out there practicing in this area? Is that on the branded side, you're going to have a detailed understanding of your patent portfolio as it relates to the commercial product, because you're not going to have time to get up to speed. You better be up to speed. And on the generic side, the minute you file that biologic application, you're off to the races within a very compressed time period, taking down infringement positions and invalidity positions. So before that application for an abbreviated approval is filed, on the generic side, you got to be ready to go. So in summary, I think you're going to see the litigation background will increasingly shift to the PTO and the ITC in litigation not involving pharmaceuticals or biosimilars. I think you're going to see increasing use of the ITC and MDL, multi-district litigation by NPEs, and you're going to see a rise in biosimilar litigation. And with that, I introduce my partner, John Gabrielides.
Thank you, Ralph. I too welcome everybody's attendance here today. I'm here to talk about 4 trademark-related topics that have recently taken place, that are occurring in the courts today, that we expect decisions on, that I think may affect trademark-related business that you all may have. First, we have the ever-evolving trademarks as keywords issue. There's been a lot of cases on this. There was a new case that's coming down, and we're waiting on an appeal on that may have interesting, far-reaching implications. We'll talk about aesthetic functionality, which is a doctrine that's been ignored for a long time, but now has new life that's been breathed into it. Broadening of the dilution standard, which is a very interesting topic that may expand the number of dilution cases that are available to our clients. And finally, trademarks in the internet with the XXX sponsored top-level domain. First, trademarks as keywords. This has been going on for a long time, but we have a wrinkle out of the Fourth Circuit. There was recently a case where Google's AdWord program has come under attack. Now, typically, when an AdWord case is brought, it's brought against the advertiser, the company that has bid on a particular term. What makes this particular case unique is that Rosetta Stone, which was the plaintiff, was upset because when people were typing in Rosetta Stone as search terms, counterfeits were coming up, but instead of going after the advertiser, they went after Google. The district court ruled that the lawsuit could not proceed because the AdWord program that Google was running was protected by the functionality doctrine. The court said that use of marks as part of this AdWords program served an essential indexing function, and that without it, Google's AdWords program could not function efficiently. Now, what's very interesting about this case is that the court really is not commenting from a trademark perspective, it's commenting from a business perspective, and basically trumping the trademark rights of trademark holders by giving Google a green light, excuse me, to continue with its AdWord program. The functionality has nothing to do with the marks, it has everything to do with the program. This represents a change, and actually what it does is it presents a broader decision base than we've seen before. What does this mean for our clients? Well, some of our clients may have felt that they want to shy away from an AdWords program because of the uncertainty in litigation. If I bid on my competitor's term, will I get sued? If I get sued, will I lose? The cases are all over the place when it comes to cases against advertisers. But this case, going against Google, may give you umbrella protection. We are waiting for a decision here. The appeal was argued in September of 2011. It was filed in the Fourth Circuit, which is an influential court in trademark matters, and this could give our clients broader protection and make AdWords program use less risky. Moving on to aesthetic functionality. This is a doctrine that has had a long and tortured history and was dormant for quite some time, but out of a fairly prominent case now in the Southern District of New York, it's gotten a lot of attention. The plaintiff in this particular case, Louboutin, had a registration for what we see on the left here on the slide, a women's shoe with a red undersole. And you'll see in the middle slide what it is that the shoe looked like in the commercial marketplace. Louboutin sued Yves Saint Laurent for making what we see on the right, a women's shoe with a red undersole. The plaintiff moved for preliminary injunction, and the court said, your registration and your claimed trademark rights are simply too broad, even if, and this is what I find to be interesting, even if the plaintiff could prove that there was secondary meaning or consumer recognition in a red undersole with women's shoes. The theory, basically, is the color depletion theory that had currency a long time ago, hasn't gotten much play lately, but now has been thrust back into the public discussion on this. The court refused to let the plaintiff cramp what others could do while letting the plaintiff paint with a full color palette. In other words, if the plaintiff could take red away from women's shoes, it would restrict competition in the women's shoe market to the detriment of competitors. Now, again, this case could be read, and may be read, depending on how the Second Circuit rules, as limited to the fashion industry. The danger, though, is that it could come down to affect any customer, or client rather, that has a consumer product that uses color in any aesthetic manner whatsoever. In other words, if I am on the defense side of this case, and it comes down favorably for Yves Saint Laurent, even if I'm not in the fashion industry, I'm going to be able to say, look, I have an aesthetic component to using this color red. Granted, I'm not making women's shoes, but I'm making, for instance, furniture. And my clients like the soothing color green that I use, or soothing color blue. If this aesthetic functionality doctrine is upheld by the Second Circuit, that will have some force. We're waiting on this as well. There was an interlocutory appeal handed down in this case. Next, I'd like to briefly discuss a case that was already decided now by the Ninth Circuit, another influential court, and that has to do with the broadening of the dilution standard. Dilution by blurring, particularly, is what we're talking about here as opposed to tarnishment. Originally, the trademark law said that a dilution case can only be brought against identical or nearly identical marks. There was an amendment to the Lanham Act whereby that language was taken out, but it wasn't really replaced with anything. So the question was, to what extent do marks that are alleged to blur a famous mark have to be identical or nearly identical? That issue had not been decided. The particular case here involved Levi's. On the left, we all know the familiar Levi's pocket. On the right, we had the challenge design. Now, I think we can all agree they're similar, but they're not identical or nearly identical. The district court found that this absence of identicality or near identicality destroyed plaintiff's claim. They couldn't bring it under dilution by blurring theory. However, the Ninth Circuit now found that because of recent amendments to the Lanham Act, that no longer is the standard. In fact, one of the factors that now applies under the dilution by blurring standard is the degree of similarity between the marks at issue. If that's one of the factors, you cannot require identicality or near identicality. The Ninth Circuit now has joined the Second Circuit, two very influential circuits in these areas. So what does that mean for us and our clients? If we have a famous mark, that's always a threshold for dilution. We no longer have to restrict the claims for dilution against those marks that are identical or nearly identical. We have broadened the universe of dilution candidates. Similarity of the marks now is simply one factor in the dilution by blurring claim. And if you're the defendant now, you have to worry about that as well. You can no longer think that because my mark is not identical or nearly identical, I am not subject to a dilution claim. And the last topic I want to address briefly is the sponsored top-level domain names. A lot of attention was given to the XXX TLDs. This was sponsored by the adult entertainment industry. A lot of dollars were at stake here. The ICANN registry made a lot of money from this program. They got $2 in every XXX domain name. There were 200,000 of those. They got $300 for every block. There were 80,000 of those. Many millions of dollars were at stake. We have passed out of the sunrise periods. We have passed out of the land rush period. We are now in the general availability period. What does that mean? That means first come, first served at this point. What does that mean for our clients? If you have a core mark of particular interest, your trade name, the trademark of a killer product, terrific service, and you have not yet reserved the XXX equivalent of that, you should do so right away as a defensive mechanism. It is impossible, or at least cost prohibitive, to come up with every variation. But as for your core marks, you should sew them up right away if you haven't done so. You should also identify infringers that are creating trouble for you in the marketplace. There are search services available that we employ and that are commercially accessible to clients, so that if there is somebody out there that is using your name in a variation with XXX, you can make a decision to go after them. How would you go after them? Typical remedies, ICANN, court proceedings. There is something called the Rapid Evaluation Service that's available, but that's limited to cases of objective, clear abuse of well-known, distinctive registered marks of significant commercial value. It's a shortened process that's available. And last, the XXX sponsored top-level domain names is not a one-time event. There will be more. They are on the horizon. .hotel, .restaurant, .consultant. They are all coming down the pike. We're going to see the same process, which resembles the Wild West. And so remaining informed about these developments coming down the pike is another good move. So with that, let me turn the presentation back over to my partner, Jim Sobieraj.
Thank you, John, Ralph, and Drew for your insights and thoughtful reflections. As I was listening to my colleagues, I jotted down a few notes and made a few of my own observations. I'd like to share those with you now. For patent owners, the message I took away is do not wait to start reviewing your policies and looking at modifying them in light of all the changes that are coming down the road as a result of the America Invents Act. There's so many changes that to me it would behoove patent owners to act now to start reviewing their policies. All these changes are not going to affect every company the same. I think it's important for every company to sit down and figure out which changes are going to affect them and how they're going to affect them, set priorities, and implement an action plan. On the litigation side, Ralph identified a number of ways in which the battlegrounds are changing, and we're starting to see them already. I get 3 reports a day on new lawsuits that are filed around the country, patent, trademark, and copyright suits. And already we're seeing the number of patent cases increase. For those of you who track statistics, I think by the end of the year we'll see a large increase just in the number of filings. And one of the reasons is before the American Invents Act, it was common to see not only NPEs, but companies, traditional manufacturing companies, file a lawsuit against multiple defendants. Now they're filing the same patent claims against 10 defendants in 10 different lawsuits. And they're also filing them in courts that have been used less frequently in the past. The Eastern District of Texas has been the favorite jurisdiction for the NPEs for a number of years. As a result of the non-joinder procedures and some other factors, we're seeing fewer cases filed in the Eastern District of Texas. Still a substantial number, but we're seeing an increasing number of cases filed in other jurisdictions around the country as patent owners, I think, are testing the waters. Delaware and the Northern District of Illinois here in Chicago are seeing a large increase in the number of cases filed. It'll be interesting to see as these issues being moved to the Patent Office. As Ralph mentioned, there's some important differences between litigating an issue in the Patent Office and in the courtroom. And one of the important differences in the Patent Office is that while any lawyer who's admitted to practice can practice in a court, in order to practice in the Patent Office, you need an additional special registration to practice there. So it's going to be important to be represented by attorneys that have both courtroom litigation skills and are registered to practice in the Patent Office and work with a team that has a very sophisticated and experienced patent practice. If I can share one more observation on the Eastern District of Texas. Last fall, I attended a judicial conference down in Texas that was sponsored by the Eastern District of Texas and the Federal Circuit. On the last day, Judge Rader, the chief judge of the Federal Circuit, gave a speech. And a lot of you may have read this, but the gist of the speech was that it's come to his attention, it's no secret, that it's widely perceived that the Eastern District of Texas is a jurisdiction that's favorable to patent owners, which accounts for the large number of cases filed there. And he shared a number of his views on things that should be done to make the playing field more level. Most of the people in the room were lawyers practicing in that district, and my impression is there was a stunned silence when he gave that speech. So in addition to changes that are going to impact the filing of cases that are being brought by some of these provisions of the American Invents Act, we're also seeing pressure from above, from the Federal Circuit, to put its fingerprint on how cases are being filed and jurisdictions are being selected around the country for new patent cases. Also the ITC. Historically, most of the cases in the ITC have been filed by high-tech electronic companies. I think what we're going to see is more cases filed there involving cases outside of that industry. And in 2012 and in the next few years, a lot of companies will have their first encounter with the ITC. For trademark owners, it sounded to me like a mixed bag. On a positive note, this broadened protection available for dilution of famous trademarks is a good development. On the other hand, trademark owners need to be concerned and vigilant about unauthorized uses of their trademarks as both keywords or by .xxx domains that, even if they're not exactly the same domain as your company. They could be confusingly similar. But yet then, the keywords, depending on the company, could be an advantage. If you have a competitive reason for wanting to use one of your competitors' keywords, there might be more flexibility and opportunity for you to do that. So a lot of significant changes. They can impact a company's IP and business objectives. And I think Drew said it, one of the key watchwords is monitor. Monitor, monitor, monitor. And figure out what you need to do and then put a plan of action in place. We have time for some questions and answers now. Is there anybody in the room that has a question for me or any of the presenters? Okay, I don't see any hands coming up. And we haven't had any questions come across the internet. Okay. Well, we know you're busy and you have other obligations today. Let me say this. If you're like me, sometimes you walk out of a room or a presentation, you think, oh, geez, I wish I would have asked that question. If that happens to you, it's not too late. You can contact me or any one of the presenters with your questions afterwards. Our website domain is www.brinkshofer.com. You can easily find my bio or the bios of any of my colleagues, along with their email addresses there. Feel free to email a question to us, and we'll respond as quickly and as best we can. Thank you again, everybody who came to our offices in Chicago today to join us, and thanks to everybody out there in cyberspace in the U.S. and in Europe who joined us. It was our pleasure and our honor to have you as attendees today. Thank you.